Hey, happy Friday. And the sun is not quite out, but it's not pouring because it's always sunny on Friday. But I am absolutely so excited to have Denise Kaplan with us today. She is an estate planner, and I can't wait to start asking you questions. So, welcome, Denise. Thank you for
Thank you
being
so
here.
much. Everyone's favorite topic, death and taxes.
Yeah, death and taxes. So, one question that I just want to start with that came up is like, okay, you have an estate plan, but what do your family members want to make sure they have access to? Just the estate plan, or do I need all my husband's login numbers, or how is that going to work?
It's such a great question, and one that I always love to help people understand. It's not just about your documents, right? Because you can give somebody documents, but if you don't really arm them with all the rest of the stuff that they might need in order to help manage your affairs, take care of you properly, they could spend a lot of time and money digging around for things. So really, you have to think about it as, what do I want to tell somebody if I could never speak to them again about where things are? And so what I usually suggest is to make sure, of course, give all the people named in estate planning documents copies of the documents themselves, but also prepare a comprehensive guide. It doesn't have to be fancy or a paid for thing. It can be one that somebody self prepares that lists everything about you, your history and your family information, and all that biographical stuff. But then also make sure to include the location of important items. Where are things stored? What are the passwords or codes to get into things? Make sure that your trusted individuals have a key to your house, or that they at least have the code. I know I change my codes on my garage and on the door and do all that stuff. So it's very important to share that. And yes, passwords are super important. Password manager with a master security key or code is really an easy thing to do. And that way you can set that up so that if there's an amount of time and that person goes in there and needs to access that, you can have all of that arranged. So all of those additional things, aside from just the key documents, people think of property powers of attorney and healthcare powers of attorney. Those are things that can help us if we're incapacitated. But the rest of that stuff is equally as important.
You have all your documents and now you're running around, especially if you're still alive. The bank doesn't just say, oh, go on in. I mean, eventually you might be able to get in, but it's a big pain.
Right. We tell people who do have a safe deposit box, add a cosigner on the box, add that person that you're going to be trusting, to try to get access to things. There's always a way, right? The law always provides a way for these type of things in the event of incapacity or death, but you will avoid a lot of expense and hassle and somebody calling a lawyer like us to try to figure out, I need to get in the box and get this thing out, or I don't know who my mom's long-term care insurance provider is. How would I figure that out? How do I, and then you get into issues of going into emails, perhaps if you haven't done documents that include the power to get to your digital property too. You're not really setting things up. There's a good way to include robust language in your documents to make sure whoever you're entrusting to handle your affairs can properly be tapping into your email and looking for things there. But if you prepare a guide with all that information, nobody has to be rooting around searching through email in the moment when you're in the hospital and they need to take care of something.
Right. I love that. I'm going to look for something like that.
You could probably find one on my website.
Oh, boy. Great. Okay. And we'll talk about that. I think we should post that. That is an absolutely fabulous idea. Okay. Let's talk about probate. Of course, I'm in real estate and I get this all the time. So we know we don't want to be in probate. What is probate? What does it mean?
Very simply, probate is the court process that pretty much every state has for when you need to handle the administration of the assets of a person who passed away. Generally speaking, there's going to be an amount of time that you have to wait while this thing is going on, because it's an orderly system where we've got a judge who can determine, was there a will, wasn't there a will, who's going to take the estate, who's going to be appointed to manage the estate, which is usually a product if there was or wasn't a will. The will would say who it is. If there wasn't a will or we ran out of the people in the will, the law has a process for that. And then we need to give time for creditors to come in and make a claim and say there was an ambulance ride and there was an outstanding credit card bill. So all of those things get sorted out in the probate process. So it needs to stay open in Illinois for a time of 6 months. And then the executor or administrator of the estate can go ahead and finish the job of handling the estate and move things forward. So the reason why people think it's nice to avoid is because it's expensive. You've got a lawyer going in to open the estate. We call it opening at the beginning, closing it at the end. There's legal fees in terms of, costs, really in terms of court costs. There's some other related costs. So it is nice to avoid when you can. And it's actually pretty easy to avoid. There are 3 ways that you can avoid it. You can use a beneficiary designation. So if you've got life insurance or retirement, make sure those beneficiaries are in order. You have enough of them in case somebody passed away. Then that is like a contract, right? It's just going to pay according to whatever that says. We could have a trust where we've set up our own rules. We don't need a judge to be weighing in if we've created a document that has governing rules for a certain amount of assets and a person who's going to take care of that. We don't need probate for that. And finally, if we own things jointly, so particularly for spouses who have bank accounts and cars and things like that, when they're owned by 2 people who very rarely die simultaneously, everything flows over straight to that survivor. And then that way it's nice and smooth. But it needs to be a certain kind of joint ownership. Joint tenancy with survivorship is what's going to shoot it over to the survivor. So they want to make sure that they check bank accounts and car titles and make sure, or real estate if they're holding a house in joint name, that it has that survivor component. So we'll zoom straight over to the survivor and then avoid probate.
So in real estate in particular, if a home, and I'm not sure that people are using the language correctly, but they'll say, well, the house is in probate, therefore the title company is going to charge an extra 5% or 2.5%, or they charge a fee. So do you know what
I've experienced title companies charging extra fees because a house is going through probate. In fact, I more experienced the reverse. When the house is not going through probate, there is an alternative process. If, let's say, all there is a house and nobody wants to go open a whole probate estate in court, there is an alternative process. People call it a bond in lieu. And usually if you're within 2 years of when the person dies, they're going to charge a premium for helping say that this house goes to these people and that the title can be good and cleanly transferred. So that's where I see a premium being charged when probate is done and the court is issuing these official letters of office, it's called, that says this is the person handling the estate. Even if that home is getting sold by the executor or it goes to the beneficiary and then they're selling it, I have not seen extra charges coming along for that.
Right. It's just, if I believe, if there is no will, I don't know, if there's no will, like what happens if you die without a will or without the property in trust
or jointly owned with someone else? That's
it's like, so the mom dies. Yep. Maybe she has a will, but she has no trust.
That's okay. We can still have probate and the real estate can be distributed under the probate process. And even if there was no will, the law says where all of our assets go. If we don't make a plan, the law will do it for you. And just to dispel any myths about that, it's not like the government gets your money. It's a statute that says, here is the ordering. If you're married, if you have kids, if you don't have kids, if you have no spouse and kids, who gets it then? So the statute covers all of that. It always will say where something goes, and an executor or an administrator, whoever's appointed by the court, can then say they need to get a title policy, because we don't really know what was going on with the ownership of that real estate when that person had owned it. And it's often a good idea to get a title policy in an estate context to make sure we know that title is good and clean before we start passing it around and selling it.
Right. So those fees, I always like to mention, just because this happened to me, and correct me if I'm wrong, Denise, but in Illinois, do you still need, for your will, a wet signature on your will?
Well, it's a great question. We now have digital signing, remote online signing. The governor authorized it during COVID, and then they have since passed a statute to extend all of that. But we have found that the process is pretty onerous. It involves a lot of technology that some people, particularly those who are perhaps have a lot of candles on their birthday cake, may not have available to them, or they're not really in, they're in the hospital for the signing. And so suddenly to have all of the right procedures at hand. So it's a wonderful thing that we have this ability to not need that wet signature, right in the moment. We can have it notarized later. They are signing it. So I guess I should more answer the question a little differently. They need a wet signature. They can't use like a DocuSign, but they don't need to sign in person anymore.
Okay.
So forgive me. I was so excited about the prospect of remote signing, but yes, we are still in a world of needing a wet signature, but not the whole everybody signing at the same time type of process, so they can be signing at home. I think we'll get there to the digital vault type of thing, and we'll get there. We're not there yet.
And what I'm really talking about is having a digital, like a copy someplace. You can't just have a non-wet signature, unnotarized, just like, okay, here's a Xerox, but a copy of this. I believe you can with your trust, but not the will.
You're right. When a person passes away, the original will is to be filed with the county. Now, so it's not during life, people often worry, but at death, the person who holds custody of a testator's whatever is considered the original, they may have signed it at a different time than the witnesses, but that's the original signature will. That needs to get filed with the court. Now, filing isn't a probate, so that's just a filing, and then sometimes you do have to go on and do the probate. But at least we need to know where the original will of a testator is. So wills should be kept in a safe place, ideally in a fireproof location and also waterproof location, so that the original will could be produced. However, if an original will goes missing, the presumption is it's presumed to have been revoked. If we can't find it, it's probably because the testator did something. But there's always a way, again, to say, you know what, it's actually lost. They didn't revoke it. It was believed this was the last one. It has been lost or misplaced. And then you may sometimes admit a copy. But of course, that's more expensive and you have to go through a process and prove it. And there's no guarantees. So everyone should be knowing where their original will is stored and make sure that they communicate that, to your good question earlier, to their chosen executor to say, here is where I keep that, so that it can be filed at the necessary time.
That's so important. So, because I think people do little bits and pieces of things, and then they get to the emotionally very difficult time anyway, and they're not thinking, and then they don't, it's like, wait, where is this? What is blah, blah, it just adds more stress to an already stressful.
It does. And there's a lot of expense involved when people have to start rooting around. They start needing to find out, well, who were the lawyers? Might it be in their law office, or where was it? And was it, superseded? Sometimes people keep lots of old records because they think it's very important. I'd say in this case, for record keeping, less is more. Keep the most current version of a will. And unless there's a very good reason that you've discussed with counsel about why you might want to keep old wills or old copies of documents that are since revoked and no longer any good, generally you don't want to do that because it just causes confusion. And really, any original will that turns up is supposed to get filed. So if we've got people holding on to 5 prior wills that they've changed every so often, now we're just creating more work and more things to deal with.
But in trusts, you need all the addendums. You need number 1, number 2, number 3.
Exactly.
That's
right.
another thing, the lay person, I got number 4. I'm going to get rid of number 1.
That's exactly right. And, a trust can have amendments, which are modifications done in a short little document. I'm just going to change Article 4 or paragraph B of Article 3. Or a trust can kind of be blown up and it can be called a restatement, which is where we did a whole fresh new document because we wanted to change so many sections. Sitting there and lining out each little thing didn't make sense. So we've just freshened it up. And now we have a restatement. I still keep all the old trust documents because it's kind of the evolution of the trust. And admittedly, not everyone wants people to see all that old history of how their choices evolved over time. But it's not a bad idea just to keep things. And like you said, even copies of trusts are useful. So even if somebody says, I really don't want all these originals, can we just keep scans of old things? We're okay with that.
Yeah. Another question that you I think is really important is, how do you pick an estate plan?
It's a great question. I think there's 2 adages that come to mind with this. So the first one is a little bit of you get what you pay for. I'll address that in a minute. The second one is that old thing we may have heard, jack of all trades, master of none. And no disrespect to my colleagues who have awesome capacity to do litigation and business work and estate planning, but this is all we do. And what we've learned from that is that there are so many things to learn from this practice. We're always learning new things, seeing challenges that informs the way we do things, that if you only do a little bit of it, perhaps you're not able to provide, all of the advice that you might otherwise be able to do if that was your singular focus. So generally speaking, we suggest that people find lawyers when they're choosing an estate planner that really does have a focus in this area. Now, maybe they have a couple of areas of focus, but somebody who is dabbling in it, or that very lovely cousin or uncle or whatever that says, I'm really whatever, bankruptcy attorney, but I can do a will for you, run the other direction. And then
I could not, and anybody that's worked with me and knows me, I feel that way about real estate attorneys. There are so many, we live in a very complicated world now. So there are so many nuances that you need, and you need for commercial, you need commercial, and for residential, you need residential.
totally.
Don't try to find out the hard way.
That's right, because we get one shot at doing this correctly. And so, it's a lot of cost, and if there's errors, it can be a really big deal. And you don't want to be in that situation. You really want things to be done well, so that at the time there is an emergency, everything is as smooth as possible. The way I view it is, it's not my job to make problems. It's my job to prevent issues and anticipate issues, and help people anticipate issues and think through what is a good way to deal with it. And it's not just about the documents. Sometimes it's about, how do you have that conversation with your family that you're not going to leave things equally, because equal isn't always the right answer for every family. And how do we deal with that during life so that we don't leave a legacy of disappointment and other bad feelings once we're not here? And so sometimes estate planning is a little bit psychology as well. And I think also, sometimes people feel that they don't want to make an investment in this. It can be expensive. I liken it a little bit to carpet, right? Carpet is expensive. Occasionally it needs to be fixed or tweaked, or something needs to be replaced, and it needs to be updated. Things change, styles change. The law is no different. Your estate planning is no different. And we make investments in things all the time, right? And really the legacy for our loved ones, our children in many cases, and or if we're doing charitable planning or other things, it makes no less sense to treat that as something that we should make an investment in initially, and then continually make sure that it is good and nice, and just like our carpet should be. And so I know it can be a bitter pill, but it's a little bit of, like I tell people, it's adulting 300. You come in and, there is nothing more grown up than approaching one's estate plan, thinking about your mortality, being organized and thoughtful. And so it's hard, and there's a cost that comes with it, but there's also a whole lot of peace of mind and saving people a whole lot of cost and aggravation.
Absolutely. Absolutely. I could not agree more. And Denise, you have been so helpful to everyone. And I'm going to go to your website and get that guide. And if it's okay, I'd love to have it available for anybody, because so important for people.
Absolutely. I'll send the link, and there's a few other little helpful things there too. People are welcome to explore. We lawyers, we say it doesn't create a lawyer-client relationship just to look. We're happy for people to grab a copy of that and use it in their lives, and sit down with anybody who they think they're going to be responsible for their affairs and say, you need to do this for me, and I need to do it for my people. So, it's a couple of hours of time, maybe more than a couple of hours of time, to get through a full comprehensive guide, and then tickle your records and update it about every year.
That is wonderful. You are going to change lives with that right now, right here today, because the people that do that are going to be thanking you over and over and over when the time comes.
Wonderful.
And I want to thank you so much. This has been great. I am thrilled that you were able to take the time, and I want to wish everybody a really happy weekend. Stay safe.
Happy Friday.
Happy Friday.